And it'll be the same thing for you because, you know, it is commercial property. It is recorded, so if there's anything that you don't want to be made public, be sure you let us know and say I'm about to disclose confidential information. And we'll make sure that you're protected.
Absolutely. And I don't think that's the case, but I appreciate it.
Okay. Are we ready? Okay, so this is an administrative hearing being held on October 23rd, 2025 in the Vermilion County Courthouse. This hearing is being recorded and will be made public via the county's YouTube channel. This hearing is being conducted pursuant to the laws of the state of Indiana as found in Indiana Code 6-1.1-1-1. This hearing being held in the manner of petition number 83-001-25-0-4-00002. The parcel number is 83-13-17-400-017.000-001. The property address is 1783 East State Road 163 in Clinton, Indiana. The assessment year under appeal is 2025. Does everyone present agree the year under appeal is as stated?
Yes.
Yes. So currently, we're showing assessed value of the land is $50,200 and improvements $631,000. My name is Pat Ritchie, and I will be conducting this hearing. Every effort will be made to keep each hearing limited to 20 minutes. Each side will be given an opportunity to present comments and evidence in support. Our PTABOA will be allowed to ask questions to each side. A decision may be made today at the hearing or taken under advisement and moved to a work session at a later date. The following persons are here representing the PTABOA: Pat Ritchie as president, Sandra Whitaker, and Brad Ringwald. Will the person representing the petitioner please identify yourself for the record?
Good afternoon, everyone. My name is Daryl Felling II. I go by Eddie.
Will the persons representing the county please identify yourselves for the record?
Kathy Gould. H. Gilmore.
Will all persons who are or may be witnesses in the hearing please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you. So we'll go ahead and begin the hearing. And Eddie, if you go ahead and tell us about your property.
Absolutely. So I'll be relatively brief. Again, my name is Eddie Felling. I'm here representing Clinton Holdings LLC. Mr. Phillips is the owner of that company. It's the strip mall there. I'm sure if you're from around here, you're all familiar with it, right off 163. There's currently 5 or 6 tenants in that building. Based upon our assessment, there are no comparable properties, even not only within 2 miles, but in the entire county. To date, based upon the rate of the increased assessment, I would assert that the burden today falls upon the county to prove what the new assessment is. So with that, and based upon the lack of evidence that's been provided to me or my client at this point, I believe the burden shifts to the county.
Okay, so we'll turn this over to Kathy.
Okay. When we had our informal hearing, I did request that information be supplied regarding the lease information and the expenses, the tenants that were there, and I have not gotten any of that. I haven't seen any of it. Paige hasn't seen anything either, so not a lot to go on other than I've done some some research and found some comparable buildings. Yes, they're not in the county, but when you're looking at anything specialized, you don't just stay right in the county. You have to go outside. Crawfordsville has 4. They had 3 strip malls where they had leases identified as part of it. Then there were 2 sales that ended up being one sale for the whole thing was $68 a square foot. This was strip malls, and the other one was $60 a square foot. Right now they're coming in at $32 a square foot. I'm just not really, haven't had anything given to me to say that what we have is not correct. we didn't do anything different to the building other than the cost tables going up, so.
May I respond to that?
Yes, you may.
For the record, obviously would object to any comparables. None of that was provided to me or my office in advance of this hearing. Again, the burden falls in this case upon the county, and if evidence not provided to the contrary, should revert to the prior year's tax assessment.
So can you tell the board what you believe the assessment should be?
Yes, it's our stance that the assessment should remain the same from 2024, which would be $443,000 flat. That would be $50,700 on the land, $392,300 on the improvements.
And you don't think the price of this property is raised?
Well, honestly, I'm an attorney. I'm not a real estate
I
agent.
understand that. I'm just saying, you know what property in general has did in the last 2 or 3 years. There'd have to be something between what it was the year before and this present year had to raise some, and you're at zero.
Right.
That's
Well,
why I'm asking.
Yeah, and honestly, the hardest, and this is just me speaking frankly, the only close comparable to this property, and again, I can't speak to Crawfordsville or anywhere else. I mean, Terre Haute, obviously, we got strip malls that go across the board, but all we've got is Walmart next door, and it's not really a comp. I understand that what they've been assessed at square foot wise is comparable to what we're analyzing here today, but I don't think they're apples to apples. Purely from an assessment standpoint, I think the county would have been well within its rights to increase 5%, and there would have been no challenge whatsoever. But unfortunately, the way the law is written, from my standpoint, it's over that 5. I don't have to say whether or not it went up or down. That's on the
I
county.
didn't ask that. I just
Right.
asked your opinion.
I am a land guy. I buy land all day long. It's the best investment you could absolutely buy.
Right.
But from an assessment, a pure assessment standpoint, I can't provide any testimony to what I think it should be other than what it's previously been assessed at.
Right.
Did the owner supply you with any of the lease?
I have
Amount?
access to all of that. I will absolutely agree that that information was requested, and I was advised that not to turn that information over wasn't required, so we did not provide that information.
Because all we have to go by is the cost tables that the state mandates that we use to start with. Then we can go to the lease agreements if the assessment's too high and see if through the
Income
income
approach.
approach.
Yeah.
5% though.
Well,
So
and
the
that's
burden
where
falls.
the problem comes in, is the 5%. I understand that 5% rule, I 100% understand that. The cost tables that were put out had increases of 20% on an average. So they're already, the DLGF is already throwing you into something that you have no other way to back up other than this is what the cost table is and this is what we did. We go back and start asking for other reasons to maybe why that isn't uniform or why it isn't legitimate or, reasonable, then we need to ask for other information. And we did and didn't get. So that's kind of where I'm at on, it's like, I went in, I was waiting for information, didn't get anything, so I started looking
At sales.
at sales and,
that's our
sales
three
and rents from
ways.
other places, and I didn't find anything, because I had my board, I searched everywhere. It was just the ones that, Crawfordsville is the one that just came up with the more things than what the, Terre Haute area did, so. Which surprised me. I really thought I'd find more in Terre Haute, but didn't.
And I think what happened, from the state, the way the tables were presented, I think put all of the counties in a bad spot
Mhm.
because of this issue.
Yes.
But
The
yes.
only way and again, I'm not an expert, but the only way I see that the counties could defend themselves by following the state is to go in and get their own appraisal done. And in this case, it didn't happen, and I don't think it's fair that the counties have to do it. That's extremely expensive to go in and get appraisals of every single property. But the way that it's set up, the taxpayer doesn't have the burden of getting their
Right,
own
I
appraisal.
understand that, I understand
And
that.
it shifts all that to the county, and just to say you're relying off the tables, which, no offense to anyone, they put them out, so I don't blame you for following them. But to not give you any ammunition other than the tables that the state put
Well,
out.
they give us the ammunition to subpoena the records.
Okay,
So, you know, we could have subpoenaed the records
right.
on the leases.
Well, yeah, we couldn't in the
No,
informal,
we
but yes,
can.
you as
Yeah,
a board,
the board
as a
can.
PTABOA absolutely can.
So that may be where we're at.
So I'll get with the county attorney, is that what you're requesting as lease agreement?
Unless the petitioner wants to willingly give the income and let us look at it, or we can give you our our figures, and you could look at it and say, is this something I want to do, to give this information? Usually we see when we go in the income approach, it does reduce the value of assessment. Can't promise that it will, because you don't know. I don't think there's been any vacancy up there. I think everything is pretty much
I think
100%
it's all
leased.
used, yeah.
And it's another approach that we can look at. And then the state says we take the lowest of the three approaches, one being sales, one being cost, or
Only on
income.
apartments.
Hmm?
It's only on apartments. The lowest of the three approaches
Yeah.
is only
Lowest of the
apartments.
three. Okay, I'm sorry, then
Yeah.
I misspoke. Okay, but it is something
Yeah.
that can be considered.
Yes, absolutely.
And I think this board is more than willing to look at that, to make our
Well-
determination.
It's not here today.
No, it's not here today.
And the way he talked, they don't want to give it. So the only alternative we would have to be extend this and subpoena it. And I think instead, we just ought to let it go and they can go to the tax court. Tax court.
It would be the next level, is what
IBTR.
she's saying, without having the
Without any
evidence we
information
need.
to change it, there's nothing we can do. I mean,
Well, if and with all due respect, the next step would be,
IBTR.
the next step would be, there wasn't any evidence provided today, therefore it reverts back to previous year's tax assessment. Because the burden today is on the county, and
Right.
Yeah, but we can,
That's okay.
okay,
So we really need to do the proceedings are done.
okay.
And then we'll discuss after you leave what we're
Okay.
gonna do. And we'll go from there.
okay.
Okay. So we will consider that these proceedings are concluded. This case is adjourned until further notice. The evidence presented or requested will be considered, and the board will render a decision. No additional evidence will be accepted for consideration unless that evidence was requested today during the hearing. You will be notified of our determination in this appeal on a Form 115. You have the right to appeal our decision issued in this manner to the Indiana Board of Tax Review. And that information, that procedure for appeal is set forth on the form that we send you. So we do appreciate you coming.
Absolutely.
Thank you.
Thank you all, appreciate your time.